You're trying to decide whether you need to use a trade secret or a patent to protect your idea. Let's get into the differences between these two types of intellectual property and when they're best used. The first big difference between a patent and a trade secret is that one is public and the other's not. You can probably guess which is which. The patent is actually a public disclosure of your invention, and the trade secret is something that you're actually not going to publicly disclose. If you're okay with public disclosure, then you can go the patent route. If it is something that public disclosure would threaten, then you'd be leaning towards the trade secret route. Number two, a patent is a pretty well-defined piece of intellectual property, whereas a trade secret could be a little bit ambiguous. This is because another party is going to know what your patent is, whereas they're not going to know what your trade secret is unless you explain it to them. So in this sense, a patent is a little bit easier to enforce because you can send a cease and desist letter saying, here's our patent, here's our claim chart, here's how what you're doing fits into our claims, and therefore you need to cease and desist. Whereas with the trade secret, you need to pursue enforcement in a little bit different of a way than that. Number three, patents automatically get you bumped into federal district court if you go to enforce them. The federal jurisdiction over patent law is plenary, meaning that the federal government has authority over all patent infringement cases. Number four, what it takes to qualify as a patented invention and what it takes to qualify as a trade secret is quite different. For something to be a patented invention, you actually have to apply for the patent from the United States Patent and Trademark Office. The USPTO is then going to examine your application to determine if it meets the requirements of the patent law. I have plenty of other videos on these, you want to check this one out. But in short, your application needs to be written in a specific way that a member of the public could read it, they could understand your invention, and they could practice it themselves. The claims need to be written in a specific way. The invention needs to be eligible for patenting. Can't be an abstract idea or something like that. It needs to be novel, it needs to be not obvious. And you need to get through the examination process, which can take anywhere from 2 to 3 years for most patent applications. The big thing about patent law is there is a legal quid pro quo involved. You are giving the public the information they need to practice your invention in exchange for a limited monopoly on that invention. Now, on the other hand, a trade secret is done a little bit differently. You don't actually apply for it. You take steps on your own to protect something, but it does have to qualify as a trade secret. This is not to be confused as just something that's confidential. A trade secret has to be something that you can define and that derives independent economic value from the fact that you've kept it secret and from the fact that it's not easily accessed. What we do when we're actually putting together a trade secret for a company's IP portfolio is we put together a plan to keep that thing out of the public eye and include the steps that need to be taken to meet those criteria of maintaining it as a trade secret. Number five, the term is quite different between a patent and a trade secret. A patent is going to be a pretty short term compared to a trade secret. Long compared to most businesses though. A patent's term is generally going to last from the date that it's granted until a date that's calculated based on 20 years from the date you filed that patent application. A trade secret, on the other hand, has an indefinite term. That means that as long as you can maintain something as a trade secret, it can retain its trade secret status and enforceability under the various trade secret laws. Number six, the expense involved with getting, maintaining, and enforcing a patent versus the expense of setting up and enforcing a trade secret is not as different as you think. A patent has a lot of upfront costs, and it's really easy to do research to determine what these costs look like, whereas a trade secret is totally custom. Building a trade secret plan really is bespoke to what that trade secret is, what your company is, what stage your company is at, so it's a little bit harder to research what a trade secret costs up front. However, as with most forms of IP, a lot of the costs come into play along the life of that piece of IP. And finally, number seven, the brass tacks. How well does this protect your business? This really is a question you need to talk to an IP lawyer about, because whether a business needs to protect something with a patent or as a trade secret is going to depend on what that thing is and what the business's goals are. And this is why I tie everything we do at Stake back to IP strategy. And that needs to fit into your business strategy. Because once we have those down, we can make a decision about whether something is ripe for patenting or whether something should be maintained as a trade secret. And once we make that decision, we can determine how we need to implement those plans. For example, something that you can keep as a trade secret, you can meet all the criteria that are needed, and that it is advantageous for your business to do so and to take the steps needed to do so, we may want to think the trade secret route. Whereas if it's something that you're sending customers, or if it's something that is going to be put into the public eye and into the public sphere, you may want to think closer to the patent route. The other thing you want to think about is the window of protection that you need. A patent, while it's going to give a shorter window compared to a trade secret, it's still 20 years from the date you file. That's a long time for most businesses, and it's also something that has a more definite and concrete value. This is how we're going to think about patents and trade secrets as we're trying to decide which one is more appropriate for the thing that your business is trying to protect.